Hey everyone, great to see you. Just like I'm the internet for you, you are the internet for me, and we never quite know what's going to happen on the internet, right? So this is my first public live stream. I do live streams periodically for members only, where folks can drop in. But depending on how this goes, maybe we'll do it a little bit more often for the folks outside the membership circle as well. I don't really have a whole lot of things immediately stacked up to talk about here. So hopefully folks will choose to participate by throwing things into the chat field. My brave wife, Jen, also sometimes intern on the channel, has graciously volunteered to copy paste questions into a document in case things get a little out of hand. So that's there. But otherwise, I did have a request from the community post I did several days ago from Tom Rolfson, longtime friend of the channel, who asked me to distinguish for folks specifically here in Wisconsin, being a Wisconsin attorney. But my suspicion is this could be of value to folks by and large. And what's the distinguishing feature between times when we have what's called sensitive locations as well as basically private property? So this kind of goes to the concept of there are times and when there are places where we are prohibited from possessing firearms, right? The question is, where does that prohibition come from? Does it come from a private property owner exercising their rights as a private property owner, whether that's a home, a retail location, like a restaurant, a mall, shopping center, something like that? And for whatever reason, they make the silly decision of saying, you know what, we're better off here having a no firearms allowed sign, which of course we all know that works great at deterring bad guys, right? I think depending on which study you want to believe, John Lott, a noted, very famous Second Amendment researcher, did a study that found that approximately 95% of mass public shootings take place in gun-free zones. He got fact-checked by the Washington Post, not exactly the most pro-Second Amendment organization out there. The fact check found out, no, Mr. Lott, you are way off. It is not about 94 or 95% of the time do mass public shootings happen in gun-free zones. It's 86% of the time. Okay, well, right. I think that just kind of belies the point that Mr. Lott may be at a minimum directionally correct and absolutely correct in the principles of the matter that we're referring to here. So sensitive locations are where the government's restricting your ability to possess and carry firearms. So think about schools, think about post offices, think about generally courthouses, legislative bodies when they're in session, things like that, polling stations. And generally speaking, at least in most states, in every state I'm familiar with, check your local listings, sensitive locations, if you violate that, you're subjected to criminal penalties, oftentimes felonies. Okay. Keep in mind that if you're in possession of a firearm, even in the post office, a parking lot, that's no go there. All right. And of course, school grounds versus being on school property itself, those can get fuzzy distinguishing features and lines depending upon where you are in each state. So the school stuff, you got to be careful about that as well. That contrasts to the private property restrictions, which in some states, they basically have virtually no enforcement of law behind them. In other states like Wisconsin, if you're in a mall, if you're in a private property location and the property owner has a sign, you get caught, you have to be asked to leave, or you can be asked to leave. If you do leave, you can put your firearm back in your motor vehicle or something like that in return. Now, they could always deny you access at that point. If you refuse to leave, you can be ticketed for Class B forfeiture violation for trespass. So you get a couple $100 ticket. But keep in mind, that is definitely not the case in every state. Many states are looking at felonies on that. All right, so we got some folks here. We've got Chuck from Texas. How do you feel about Go Safe? I don't know. Jerry's braving it up in Illinois. Jody, thank you very much for those kind words. Jason, another brave person from behind the wall in Massachusetts. William, I appreciate your vote in the Gundies. Thank you. You know, I definitely, I'm not someone who typically wins popularity contests. And by typically, I mean, I think the last popularity contest I won is I think I got voted captain of my 7th grade ice hockey team. But Yeah, so I'm not anticipating this is going to really work out, but it's just fun to be part of the process. And I've gotten over the last year to know a lot of the people involved in the Second Amendment YouTube space. I only knew a couple of them before I really decided to make a push on the channel almost a year ago. And I've had really the pleasure and the privilege. I know that's really trite and kind of saccharine for a lot of people to say that, but there's some really good people that I've had the pleasure of meeting. Um, Jared from Guns and Gadgets, awesome guy, awesome guy. Johnny Bragg, fantastic guy. Um, Braden from Langley Outdoor Academy, great guy. There's a bunch of guys. I can keep going on and on and on. Just spoke to William Kirk from Washington Gun Law just this past week. Seems like a great guy. So, anyway, let's get to some of your questions here. So, in your opinion, what is the likelihood SCOTUS will overturn the Illinois AR ban? Yeah, that is obviously a huge question. And there's lots of things layered into that. I think as it stands right now, we may see a 5-4 overturn. In other words, Second Amendment victory. I have a feeling like maybe Roberts or someone like that will defect. And we're also assuming that it gets into court with the current lineup of justices that we have. So, God forbid, time takes one of the justices from us and there's a new appointment that is put in there by President Biden. I don't think we really have a margin to lose on this. I think Justice Thomas, Alito, Gorsuch, I think those are three firmly pro 2A judges. And then I think it gets a little murky after that, to say the least. So I think Amy Coney Barrett is going to come through in a positive direction. And then we'll see kind of where it goes from there. So bottom line is I do think that it's going to wind up going through on this. So I'm excited about that. This next one's from Rickle138. Hi, Tom. You report about many states other than Connecticut, which has very restrictive gun laws. Do you believe that SCOTUS will take up these restrictions like Illinois? For sure. I absolutely believe that in the next 4 years, we're going to see the U.S. Supreme Court address a lot of issues that remain out there. So particularly when I talk about that, the so-called assault weapons bans, I think that's going to be something that's addressed out there. Now, for Illinois, you not only have, of course, the restrictions on modern sporting rifles, i.e. AR-15s, AR-10s, AUGs, M1As, AKs, all that kind of stuff, but you also see restrictions built in on so-called high-capacity magazines, right? So above 15 rounds. So for that particular case, I hope that they're going to address both of them. I obviously hope that they're going to do it favorably. If people want to, I've done some videos talking about what are some of the argument lines there. So I'll be getting into that kind of stuff if people want me to, about whether or not the arguments surrounding whether or not a magazine is actually protected by the Second Amendment or not. So that's kind of out there. But yeah, no, I do think that we'll be getting into that. In addition to the 3 cases that the Second Amendment is already in front of the Supreme Court on, one of which has gone through oral arguments back on November 7th. That was U.S. versus Rahimi. And then we've got 2 more, NRA versus Vulo. And can't believe I'm blanking on the other one right now. But we've got 3 cases in front of the U.S. Supreme Court where one's oral arguments, 2 they've accepted to hear them next year. So, and I think there's going to be probably another. So we've got the assault weapons ban issue, so to speak, going up there. I think that's coming. We got what accessories are going to be considered under the Second Amendment. I wouldn't be surprised if we see an NFA issue get up there. There's a gentleman representing himself. So in other words, we would say he's pro se. That's DeWild in Wyoming, I want to say off the top of my head. That's actually a case. I haven't done any videos about it, but it's a case I have been following, just for fun. I could do a video about it if people want, but it's I appreciate what he's doing. He's not represented, and he's kind of making some unforced errors as a result, but we'll see where it winds up going. Those issues are going to be out there. I think there's going to be a sensitive locations case that's going to be coming up. I expect one of those to go out there. There's a bunch of very anti-gun states that have tried to do a private property inversion. So what I mean by that is, whereas most states, it's lawful to carry your firearm into a gas station, a grocery store, a restaurant, unless they post otherwise. Well, what I think New York may have been the first state to do that, where they said, no, it's all illegal unless they post to allow. So I think you'll see a private property inversion case and something kind of tied into sensitive locations. And there's a bunch of those working their way through federal court right now. I've covered a variety of them on the channel as well. This one's, we're going to skip ahead, have to do that, for Libertarian Neighbor. So Libertarian Neighbor, thank you very much for the super chat. I'm seeing all these decisions in state and federal courts, but nothing changes in California. What will it take to see us have some of our rights restored? Thanks. We've seen some things, obviously kind of ticking through the Ninth Circuit Court of Appeals, which is no longer considered to be the most anti-Second Amendment circuit out there. In speaking to, I asked that question of Lucas Weber of Wisconsin Institute for Law and Liberty. Can't remember if I asked it on or off the camera, but I did ask him the question of, hey, what are some really pro liberty-minded circuits out there, and what are the ones that are very anti? And he, as I recall, did not list the antis among the Ninth Circuit. The reason why I'm citing him is because he's an attorney who sues the government like full time. That's his job. And he's actually the guy who won the pistol brace issue. That is the reason why the whole pistol brace issue has been put on ice for the time being. So a relevant citation there to Lucas Weber. I did a video with him some months ago now where we explicitly dive into what ultimately has turned out to be the case to put the pistol brace issue on ice. But look, to your question, Libertarian Neighbor, the problem is when you live in, and this is where I think things are going to be going, is you're going to see this vicious game of whack-a-mole where courts, particularly federal appellate courts like the circuit courts, because recall we've got federal district courts, and there's about 94 of those. Those are the federal trial courts. Then we've got 13 federal circuit courts. That's where you appeal to. And then above that, we've got the U.S. Supreme Court. I think what we're going to keep seeing is these super anti-Second Amendment states are just going to continuously keep passing laws that are just ever so slightly, best case scenario, outside the purview of whatever the U.S. Supreme Court or Federal Circuit Court of Appeals swats down. So do I expect to see better case law continue to come down? It's certainly looking like that. Do I expect to see things mechanically change on the ground for a lot of folks in very anti-Second Amendment states? I don't know. I think they're just going to keep hammering away with anti-Second Amendment laws, because what do they really have to lose at the end of the day for that? But it's unfortunate, but that's what I think is going to happen. So I wish I had something else better to say about that, but there you go. Thank you, Libertarian. Nicholas Colucci. I apologize if I mispronounce anyone's name. Any word on the New York CCIA Second Circuit case, and what's the holdup? I don't know offhand. I'm somebody just candidly who the way my brain works, I tend to struggle with case names slightly. Just like if I meet an individual live in person, I tend to have to meet them 2 or 3 times to get their name to stick. That's just me and my own defect. My point is that if I had like a sentence to describe the fact pattern, I have thankfully a really good memory to maybe compensate for the naming issue. So off the top of my head, I'm sorry, Nicholas, that just isn't ringing a bell for what that is. But maybe if you can post a word or two up about that, it'll jog my memory. Next one comes from Nicholas Theodore. Tom, please explain why politicians and judges can forsake their oath to serve, defend, and protect the Constitution. Yeah, well, boy, if we can figure that one out, we've really advanced society quite a bit, right? I mean, look, I think a lot of this just comes down to the fact that there's very different conceptions of what the Constitution is, coming from different spots in the political spectrum. Obviously, people who tend to veer more right often fall in the camp with different permutations of saying, look, the Second Amendment is part of the Constitution, which is basically part of our contract, right? and our contract with our ancestors through history to provide stability, continuity, and the rules of how we're supposed to be playing this game. And there's rules on how you are to amend the rules as well. And obviously, I don't think I'm saying anything controversial here. And even if I am, I don't care. The founding fathers had pretty dim views of centralized and powerful government from faraway places as a result of their direct experience with England and Great Britain. So they wrote a government and a charter that was maybe not the most efficient at getting things done, unlike a very highly centralized power like France and a lot of continental countries, right? And a lot of people don't like that. If you're trying to change the system, now let's kind of go to people on the, wrapping up the people on the right. The people on the right view that, look, we are to conduct our laws and view our laws in the context of the spirit with which they were created. And if there's a question as to how we are to interpret the laws, if it's an old law, we are to, like the Constitution and the amendments, we're to look to what the founding fathers and the framers' intent was. And folks on the left really don't like that. They view it as the dead hand of history controlling. They view it as a whole bunch of different things. But generally speaking, within the domain of law, they tend to have this living, breathing document view of the Constitution and the amendments, which is, look, here's some founding principles, but we really ought to have a much broader hand and a much freer hand as to how we are to interpret and apply these as we move across time. Because who's going to be in the better place to decide what we need as a society? Some guys a couple hundred years ago or people today? And within that perspective, they view, obviously, the conservatives as the bad guys and the liberals as the good guys. And obviously, within the conservative paradigm, it's the exact opposite. So the reason why I say that, Nicholas, is because I think that depending upon what your perspective is, you're going to say, I'm the good guy, you're the bad guy, and vice versa. As far as what are we going to have to do to fix those perspectives, to unify them, I don't see any unification at any point in time. I think that politics is downstream of culture, and our culture is increasingly bipolar. It was a good question. Next one is the downward machine. What gun restrictions do you support? Or do you support all guns available to all people in all places at all times? Interesting question. And candidly, not one that, to be perfectly honest with you, I don't spend a tremendous amount of time thinking about that. In part because I tend to be maybe too much of a realist, and I don't really tend to spend any time thinking about what some sort of Tom Grieve utopian society would look like. I don't think we're going to be getting there, even if we did. Let's put it that way. Yeah, what kind of things would I want to see or not want to see? Well, I would want to see a lot less of what we have on the books. Just at a minimum, let's get that out there. I want to have very loose carry laws, if any laws at all. I mean, if you want to backtrack that, I probably would just want to see universal constitutional carry or permitless carry. The fact that I just answered the question like that, immediately corrected myself, just goes to show you I don't spend time thinking about these questions, but maybe I should. So I'm going to pocket that one, and maybe I'll have to do a video about that down the line, because that's kind of an interesting question. All right. Well, I appreciate that. Rug the Caveman is someone with no criminal history in Washington state is currently being convicted of a Class C felony nonviolent crime based in state definition. I'm not a Washington state attorney, so I'm going to have to interpret this with my Wisconsin eyes. So bottom line, if somebody's convicted of a nonviolent felony, does Bruin have a section that covers that? I think what you're asking, Rug, and thank you for the question, if I had to guess, is basically, do I see a change coming to our prohibited possessor laws, specifically those that deal with persons who have been convicted of some sort of felony? I think we're getting the answer to that really quickly. So the U.S. Supreme Court heard the oral arguments in U.S. versus Rahimi that explicitly deals with the domestic injunction laws, where people who have a qualifying domestic abuse injunction against them are prohibited from possessing weapons. That's what it explicitly deals with. It implicitly may very well veer into exactly your question. Here's why. The fundamental question that we're talking about is, who are the people in the phrase, the right of the people to keep and bear arms shall not be infringed? So who is the political community that the Second Amendment is aimed at protecting? And at what points, if any, is the government allowed to exclude people, or do people exclude themselves potentially based on history and tradition from that community? So I think that there's, the laws that are out there from my reading, I think it might be tough to let's put on the realistic hat, just because there's no point in talking about, again, Tom's utopia. I don't see laws changing that prohibit people convicted of a violent felony. I don't think that's going to change. The domestic abuse injunctions might, but this is an awful fact pattern going before the U.S. Supreme Court on this issue. And there's the old saying that bad facts make bad law. So we've got a bad fact pattern, U.S. versus Rahimi. It's one that if I was part of the Department of Justice and I wanted to uphold the law that was out there, and by that, I'm certainly not talking about the Second Amendment, Rahimi is a perfect case because the guy he's just a bad guy. If you look into his history and record and everything he's accused of and has been convicted of, just ugly case. But I also know how incredibly easy it is to get these domestic abuse injunctions put on people. If you go into court, you basically utter the magic words, there's a good chance that a commissioner or judge is going to do it out of the defensive practice of law, which I'm by no means supporting, condoning, endorsing, but I have seen this. So I think to me that's going to be, if we're talking practically what undoes it, it might be that. There's also a case, I want to say, working its way through the Third Circuit that I've covered on this channel that has dealt with this violent felon issue. So that might be something to kind of poke into as well. I don't think it's going to happen for for violent felons or people who've been convicted of a violent felony. I'm toss up on nonviolent felonies. It's going to be a toss up. And there was a case in, I forget, it was 1980 or something like that, where the U.S. Supreme Court, U.S. v. Lewis, in a recent video I did where I ranked 9 U.S. Supreme Court cases that touched the Second Amendment in order of importance. That was just this past week where I briefly touched on that case too. All right, we've got a couple super chats. So let's veer out of our lane to go into those. So we've got Mike Yu. Thank you, Mike. Can the Supreme Court impose penalties for clearly acting against their rulings and wasting the court's time? So there's a case, if you go back to Andrew Jackson, I want to say, and this is a case that every lawyer learns about in law school. And I don't want to try to quote the case because the last time I touched it was in another lifetime now. But the gist to it, as I recall, went something like this. Basically, Andrew Jackson, of course, as president at the time, viewed something one way, and the U.S. Supreme Court viewed it entirely another way. And the U.S. Supreme Court basically came out with a ruling that rebuked him. And Jackson famously remarked, "Let them enforce it." And to my memory, really nothing happened. I want to say it dealt with indigenous peoples, Native Americans. The Cherokee comes to mind. I apologize if I'm way off base, but it has been a long time since I've thought about that case. I guess, Mike, to your point, you can look, my heart is with you when it comes to what do we do to shut these clowns down, right? From a practical standpoint, it's supposed to be the executive branch that enforces the laws passed by the legislative, as well as the rulings passed by the judiciary. If the executive branch chooses not to participate in that, or the legislative branch, as the case may be, particularly when we look to the states, if we start giving executive branch controls to the judiciary, we may solve a problem, but if we created a bigger one, I don't think there's a perfect answer to that. And it's a great question, but I think you can kind of see we get to some real important balance of power and constitutional issues kind of wrapped into it. So it's a great question, Mike. Bottom line, I don't see the US Supreme Court taking any specific action on it. And I think it's a separate argument as to whether or not that's a good thing or a bad thing when we start talking about the Republic. So thank you. Blake, another super chat. Thank you, Blake. What steps can we take to stop presidents like Donald Trump's bump stock ban from banning firearm features? Great question, Blake. So that kind of goes right back in what we were just talking about, right? Because, of course, effectively, President Trump ordered the ATF to enact the ban, and I've covered a lot of the details and painstaking feature when it comes to the bump stock ban. I mean, basically, this is really coming down to the power of the executive branch. We're talking about largely the ATF, but really we're talking about anything that doesn't emerge from Congress. And even if it does emerge from Congress or a state government, it still has to obviously pass constitutional muster, right? So I think what your question is basically asking is, how do we stop, whether it's presidents or I would expand it to legislative bodies, from violating the Constitution? Elect better legislators, elect people that are more interested in seeing the long game rather than the short game. And that's not a political shot at anyone. That's just an observation of the problem that we have with the 24-hour news cycle and a media that has to sensationalize things in order to meet payroll, and fight for clicks and fight for screen time and everything else. And everybody demands action and satisfaction right now. You know, I often say, and I've said it before and I'll say it again, I wish there was a way that we could somehow train the media, society, and our culture to evaluate laws based on their impact, not on their stated intent. Because if we could do that, that would at least be a start. But I think if we get young people more exposed to the importance of the Constitution, so I think it starts in the classroom, it starts in the home, of why we have the Constitution, where did it come from, why is it important? I think that hopefully we can build and start to reverse a lot of the cultural tide that we've dealt with, that has served to erode the Republic, right? So I hope that goes to address that. This next one comes from Garrett. Garrett, another super chat. Thank you very much, sir. I live in California. I am so sorry, Garrett. Though, as I'm looking outside at like a 34-degree rainy day, gray day in Wisconsin, maybe I'm not so sorry. But he works as an armed guard with my BSIS exposed permit. Unfortunately, my Orange County Sheriff's Department denied my CCW. Reason, restraining order in 2018, but it was expunged. Any tips? The biggest tip I can give you is talk to a qualified attorney. If this was in Wisconsin, if you're no longer engaged with an active qualifying domestic abuse or harassment injunction, the second that injunction ends, you're good to go. So it sounds like there may be some weird feature to California law, which I would not be surprised about, that suggests that it's somehow permanently on your record like a conviction. I would also go back, if you can obtain the copy of the order from the clerk of courts or whoever the issuing agency or department was, and see what the specific wording is. I will also say that I've seen a lot of mistakes come from government. You're all shocked. I know. Hopefully you were sitting down. Nobody was driving when you heard that. I've seen a lot of mistakes happen from government, where government, as well as private background check companies for like employment and so forth, where they just make a lot of mistakes on reading and how to understand what's on someone's record. So I'm not even convinced that you're necessarily wrong. Obviously, I'm not an attorney in California. This is not legal advice. My only legal advice is talk to a qualified California attorney on it. But bottom line, you may not be disqualified right now. Get the copy of the order, read it. How long does the disqualification last under both the order as well as California law? I have no idea what effect, if any, a California expungement might be. I'm assuming this is under California Penal Code 1203.4, which allows a lot of things to get expunged. But yeah, sorry, Garrett. I wish you the best of luck on it. All right, let's scroll back up. I think that's it for the super chats for the time being. And let's keep going with those questions. So I think it goes down to Jason. Jason asks, are we safe now with our pistol braces back on our AR pistols? Great question, Jason. And for those of you who have been following the channel, you know that it's not very often I get to break news, but I was able to break the news nationally on the pistol brace issue. And credit for that goes to my friend Lucas Weber, who is the attorney who got that injunction. And he very kindly texted it to me before any of that was really publicly available knowledge. I mean, it was all publicly available instantly, but before it really got out there. So are we safe now? We're safe for the time being. Where does it go from here? I don't know. So they've already filed an appeal on it. The ATF, the DOJ has already filed an appeal on that. It's going to go to the Fifth Circuit, who's like, they're not going to get anywhere with that. So this is going to probably wind up going to the Supreme Court. And I think that, again, this issue, the Venn diagrams largely cross-sect and intersect with the Protect Illinois Communities Act, which is the so-called assault weapon and magazine ban, where we're dealing with a lot of fundamental questions, such as what constitutes a weapon, what constitutes an arm under the Second Amendment. Because a lot of the anti-crowd is saying, look, a magazine, that's not a weapon. That's an accoutrement. It's not protected by the Second Amendment. Same thing when it comes to the pistol braces and things like that, right? So we've got initial questions of, is it even subject to Second Amendment protections? And if it's not, we're probably going to lose. If it is, then you get into discussions surrounding whether it's in common use, whether it somehow upstrokes a weapon to becoming dangerous and unusual. You get into questions surrounding the historical tradition test. So you get into lots of those sorts of discussions. To circle back around for you, Jason, I think we're safe right now. And I think that safety is probably, barring the U.S. Supreme Court basically does something like they did with the frame receiver rule, where the ATF is going to probably lose again in the Fifth Circuit. So that's like December, January. And then they appealed to the U.S. Supreme Court again. What the U.S. Supreme Court did in the frames receiver rules, they said, look, we are going to leave this rule in place until we say otherwise. But lower courts keep going ahead, hearing the cases, but we are basically saying the frame receiver rule stands in place. Unless the U.S. Supreme Court does something like that, I think we've got at a minimum weeks, if not months, and God willing in perpetuity, for the pistol braces to be in place. This one comes from Jerry Drolshagen. How's it going, Jerry? There's a name I know, good Wisconsin name. Can you cover duty to retreat? Yeah. So, and I hope you're not asking in a specific Wisconsin context, because our specific Wisconsin context is very messed up. Duty to retreat basically stands for the premise that before you can defend yourself with deadly force, you have to first reasonably exhaust all options of retreat. That's it in a nutshell. And it's insane, but that's it in a nutshell. If you do not have a duty to retreat, but we're not in the opposite of duty to retreat, which is stand your ground, then you've got to really be careful about checking what your local listings say about what they don't call it a duty, but effectively what your obligations are to retreat. Perfect example, Wisconsin. Wisconsin, we actually have no statutory duty to retreat. The legislature has never created a duty, has not in the last 120 some odd years created a duty to retreat, okay? However, if you were a defendant in Wisconsin courts, the jury instructions, those are the rules read to the jury to give them the instructions on how they are to interpret, understand, and apply the facts to the law and the law to the facts, will say something like this. There is no duty to retreat in Wisconsin. However, and you may as well just say but, right? However, you may consider the defendant's opportunity to retreat when deciding how reasonable his or her use of force was. It's not directly verbatim. I'm doing it from memory, but that's pretty darn close. So you don't have a duty to retreat, but the defense and the jury may absolutely consider the defendant's opportunity to retreat when deciding how reasonable was their use of force, which I don't know about you, but that basically sounds like a duty to retreat. So that's unfortunately where we are right now in Wisconsin. But right. So that's kind of duty to retreat. And stand your ground generally stands for the premise of the fact that if you are and again, this will vary from state to state, location to location, but if you are in a location where it is lawful for you to be, then you do not need to retreat. You can basically meet force by force. And Jerry, extra little Wisconsin tidbit for you. There's actually a case from, I want to say 1908 from the Wisconsin Supreme Court, actually struck down the duty to retreat in Wisconsin, which was statutory. And it was pretty common to see that across the later portion of the 19th century, across a lot of states and territories. So there you go. And we've got one from Mike Yu. Mike, there's a name I recognize as well. With the duty to retreat, if your family's in danger and you cannot retreat, can you defend them? Yeah, because at that point, I would argue that it is a defensive of other or defensive third person, where that third person or other cannot retreat. Okay, so right. If you've got babies in a stroller or something like that, or if you're like me and you just have like a flock of young children and having them outrun presumably a military-aged male who's assaulting you and attacking you or threatening you or something like that is basically just a non-starter. Then you do get into those sorts of considerations. Now, depending on how the case goes, there's still probably going to be a duty to retreat instruction read in court. And I'm not suggesting that that's fair or I like it, but that's basically the pushback, is a defensive third person possibly coupled with the necessity defense, depending upon how the laws in your particular jurisdiction work. So great seeing you, Mike. This next one comes from Renenko. How long until SCOTUS, the U.S. Supreme Court, gets a magazine or assault weapons ban case? Yep. I mentioned that before. I think it's going to be coming out of Illinois, and I think they're going to be getting to it in 2024 or 2025. I think that's when we're going to get to it. Art Pollard asks, what would it take to split the Ninth Circuit and move the most liberal judges to Helena, Montana, where the winters are balmy? Who has the authority to split a circuit court? Great question. Interesting question. I've never looked that up before. I suspect it would be, my gut says Congress, but I don't know, because of course, if we go back to the 1930s, we had FDR packed the U.S. Supreme Court in order to get what he wanted, as we've seen people argue about doing today, right? So I don't know if that's strictly executive. It's not really an issue I've looked into. Thankfully, I haven't felt terribly threatened by that, even though we do live in the reasonably anti-Second Amendment Seventh Circuit here in Wisconsin. But yeah, that's an interesting question. And I would point out, Art, what I mentioned before, which is the fact that actually the Ninth Circuit is by no means, from information I have, super anti-Second Amendment, or is by no means the most anti-Second Amendment by any stretch. I think you can look at some other circuits. So there you go. Next one comes from Bora Bora. Why are local municipal assault weapon bans allowed in states with supremacy clauses in which states do not have their own assault weapons ban? So a couple things to unpack there for people. So Bora Bora is basically asking something. He's using the phrase a supremacy clause. You can oftentimes see this in Second Amendment law as a state preemption law. And that works something like this. We have that here in Wisconsin. What it means is that you have kind of the level of gun laws that are, and regulations that are passed by the state, right? And then you have whatever the local municipalities. So we're talking cities, town, villages, and counties. In Wisconsin, because we have state preemption, that means that our blue anti-Second Amendment counties, like Milwaukee, Dane, that's where Madison is, they're not allowed to pass AR-15 bans. They're not allowed to pass magazine restrictions because they're not allowed to pass anything that's more restrictive than what exists at the state level. So that's the gist of that. And that's why that's so important. It's something that I'm sure a lot of folks in Colorado wished they passed 20 years ago when the state was a little bit more Second Amendment pro than it was right now, as we're seeing a checkerboard emerge across Colorado, what's legal and what's illegal. But to your question, Bora, why are basically certain areas and municipalities allowed to break this? I don't know, but I'll hazard a guess, which is it has to do with when it comes to magazine bans, claiming that they're not protected by the Second Amendment, they're not an arm, therefore they can regulate them all they want. And by extension, claiming that AR-15s are dangerous and unusual weapon, which is absurd, but that would be the argument. And therefore, they're not subjected to Second Amendment protections. Now, of course, the pushback is this is statutory protections when we're talking about supremacy clauses and state preemption laws. But those are my guesses on it. This next one comes from Mama Duke's Lisa. I think I got that. Have you heard that Florida now has a law that you do not have to have a concealed carry permit to get a firearm to conceal carry? Do you think this will be a trend in other states? Has been a trend, is a trend, will continue to be a trend. I forget if we're at 29 or 30 states now that have something resembling constitutional and permitless carry. But that's approximately where we're at. So I expect that maybe to expand by another small handful of states until we kind of hit the blue wall of states that are just never going to do that. But I think there's a couple more states that could be peeled off to that. So yeah. Next one comes from Pistol Pete. Is it true that Wisconsinites eat cheese with every meal? Depends what your definition of cheese is. If your definition of cheese includes Kraft slices and Velveeta, then we absolutely deny that accusation. If your question is whether or not it is pure, I can't do a Scarface and Al Pacino, when he's like, it's puro. I can't roll R's. But yeah, a pure Wisconsin cheddar, you just have to come here and find out. That's all I got to say. Got to find out what we're putting down on our plates and our arteries. Next one comes from Michael McLean. Which state assault weapons ban will reach SCOTUS first? Illinois. I think it's going to be Illinois. If I had to bet, Illinois. Renenko asks, do you think Miller or Bianchi gets the SCOTUS first? Don't know. And as I mentioned before, sorry, I'm not super great with remembering case names. So a sentence to remind, I recognize those names, but I can't attach meanings to them. Apologies. This one comes from a Vera Goozer commenter. What are the top 4 2A changes you expect to see in 2024? Top 4 2A changes. Well, look, we're going to see some case outcomes for sure coming from the U.S. Supreme Court. Rahimi's going to get decided. That's going to go to who are the people in the rights of, and the phrase of, the rights of the people to keep and bear arms shall not be infringed, right? So we're going to get hopefully a glimpse of what the Supreme Court thinks are the people. And by doing so, we're going to be getting an extension of looking at how the Supreme Court may continue to develop the history and tradition analysis. One of the big questions out there, for those of you who know things, we're talking about the Bruen court decision, Bruen, for those of you on your lawnmowers. The 2022 Bruen court decision said that, look, if a firearm law or regulation impacts the Second Amendment or is protected by the Second Amendment, falls within the Second Amendment, then it must also fall within the nation's history and tradition. Now, there's obscure exceptions to that, which I've covered in one video. But aside from those obscure exceptions that are the end around the history and tradition analysis, it has to fall within history and tradition. Generally speaking, if there's an issue that our forefathers have confronted, than if it's analogous. So for instance, like someone being drunk with a weapon, right? They certainly had alcohol 200 years ago. They certainly had intoxicating beverages and intoxicating things a couple hundred years ago. So you get to questions such as whether or not if somebody has a controlled substance in their bloodstream, is this something new that we've never seen before in history? And therefore, it can be an exception to the history and tradition analysis. And there need not necessarily be a direct historical analog or twin to the history and tradition analysis. Or is this something that we've kind of seen before and it really needs to be found in history and tradition in order to uphold it? So that's the reason why I'm citing this as part of this question. When you asked what are the top 4 2A changes, is because I think the U.S. Supreme Court applying a history and tradition analysis check is going to absolutely constitute a massive change. Do they give us guidance on what constitutes an era of history and tradition that we are allowed to draw from? Does history and tradition, can it be sourced alone and exclusively from the early Republic era? So from early 1800s and back to colonial and so forth? Or as the Second Amendment anti and the civilian disarmament crowd want, are they allowed to go through, well, heck, some of them claim the 1990s is history and tradition. But for the most part in court, that may be what they're saying out loud politically, but in court, they're basically arguing, with the exception of the NFA and the Gun Control Act and that kind of stuff, they're generally pushing for post-Civil War Reconstruction through end of the 19th century. So I think that's going to be at least 2 that we're going to see right there. Who are the people? And we're going to learn a lot more about this test that we know is going to be super important. I think we're also going to see exceptions to that test. I think we're going to see some answers as to whether or not magazines and other so-called accoutrements and accessories, are they protected by the Second Amendment or not? That's going to be a big deal. Whether we're talking bump stocks, pistol braces, magazines, you name it. Where, if any, line is there going to be a line drawn? I think those are going to be some big issues coming up, as well as sensitive locations. Where and what are the lines that the government is allowed to draw as a sensitive location? Is it basically everywhere? Which we know isn't going to be the case, but how far can they expand that? And I've done a number of videos on that. I could whip off some stuff from memory if people want to, but for now, I'll put it down at that. So we've got a super chat coming in from Steven. Steven, thank you. If in Illinois you have a pistol of, let's say, 16.17, and I'm going to go, I suspect there's a copy paste error. Let me find this chat. Because what I'm seeing in my doc isn't super makes sense. If in Illinois, I see nowhere M1 carbine needs to be registered, although mags can go up to 40. If in Illinois you have a pistol of, let's say, 16.17, oh, okay, 16 or 17 or 22 rounds, I bet is what they're asking. Got it. Yep, I see you, Steven. You just said that too. Fantastic. Okay. Does that need to be registered? My understanding is yes, but I'm also not an Illinois law attorney. I hope to see this reversed. There's currently something that's been pushed up to the U.S. Supreme Court. We'll see what happens. But yeah, I'll have to do a little bit more digging on this particular issue. I've actually got some inquiries into some different folks on some of the more specifics for my friends south of the Cheddar Wall. I did a number of videos about the Protect Illinois Communities Law Act maybe 7 months or so ago, where I went into a lot of the details. And since then, I've been only kind of just updating people on what's going on at the court and all that kind of stuff. This is really a question that gets back to that. So I don't know if they have to be serialized off the top of my head. Sorry, that's a question I used to know. If you probably go back 7 months, give or take, to those videos that I did. Yeah, I see nowhere M1 carbine needs to be registered, although the mags can be up to 40. Yeah, I mean, the same thing's true for, I mean, there's lots of different so-called high capacity magazines that can be slipped into various weapons, depending upon what the free market has provided. So it's a great question, Stephen. Maybe what I'll do is keep an eye on the community tab. If you know where, Stephen, do you know where the community tab is on the channel? It's where I post, like the quotes of the day, that kind of stuff. What I'll try to do for you, given the fact that this was a super chat and I don't have an answer off the top of my head, maybe what I'll try to do is I'll try to track down that answer and post it up on the community tab for you. So if you just kind of click on my channel, and then it brings you kind of my YouTube channel homepage, and there's a bunch of tabs like videos, that kind of stuff. You click community. I post things every single day there, just about. So stay tuned for that. Stay tuned for that. Okay, this one goes to XX. What's the likelihood of an assault weapons ban 2.0 getting through the Senate/House, i.e. the Go Safe Act? I mean, we're always one election away from something getting through. So as it stands right now, I would say not great to get through. We're in that time of year where both sides are kind of passing virtue signaling bills, or they're writing virtue signaling bills to try to get their donor base and everybody, fired up to turn out to vote. So I expect that this is going to be by no means the last crazy thing, because of course now they're going to say, well, Republicans want to, get grandma shot with an AR-15, for instance, right? So I don't think it's going to pass, but hey, if there's a couple insane shooters that are out there, you never know who they could, who the antis from either party, who the antis are, because there's pros in the Democrat Party too. I actually did an interview video with a very pro Second Amendment gentleman who self-identifies as being extraordinarily liberal, left-wing. And I think I've got 2 videos lined up in the hopper that need to go out. We had a very pleasant and friendly discussion about all this sorts of stuff. I'm citing that because he predicts, and I'm skeptical, but he predicts that the Democratic Party will flip to be pro-gun by the year 2032, about that presidential election cycle. We'll see. We'll see. I think that would be great. I don't think the Second Amendment should be as political as it is, but what do I know, right? Next one comes from Tom L. Please discuss how jury nullification can be utilized to counter such draconian laws such as pistol braces, duty to retreat, etc. Right? So jury nullification, for those of you who somehow don't know, is the concept that a jury basically has the ability to nullify a law that they don't like by simply voting not guilty. That's it in a nutshell. Now, something that a lot of people don't know or may not know is the fact that trial attorneys are not allowed, at least I'm not familiar with any state where they are allowed, to argue in favor of jury nullification. So if, for instance, there was some sort of pistol brace issue that myself or an attorney at my firm was defending someone on in Wisconsin trial court, we could not utter the words jury nullification. We could be sanctioned by the court, found in contempt, and we could lose our law license. And I'm not supporting necessarily that that's the way it is, but it is the way that it is. I'm citing that so that Tom, that juries just have to know, because they're not going to hear someone in court say that you can do this. Maybe if someone's pro se and represents themselves, because there's no law license to take away, a judge may be forced to kind of sit through those sorts of arguments. You can also find it buried. Jury nullification powers are buried in the specific jury instructions. So you have the laws written by the legislature, right? If you ever tried to read those for your state, you can realize these are confusing, they're wordy. You need definitions from all over the book, all over the legal books, and they cite everywhere. That's too complicated. So there's something called jury instructions, where there's these unelected committees, often of retired judges, who will write these jury instructions that basically they look like scripts that a judge, together with arguments from the parties, the prosecutor and the defense attorney in the case of a criminal case, will argue, hey, I want this instruction read for the jury defining what evidence is, or I don't want this one, I would prefer this one, or things like that. Well, when it comes to criminal jury instructions, at least here in Wisconsin, if you read it very carefully, what they say is this. They say that so this is the judge addressing the jury, if the state is unable to meet its burden of proving each element beyond a reasonable doubt, then you must, or you shall, find the defendant not guilty. So if the state cannot meet its burden, you must. But it says, curiously, if the state has met its burden of proving each of the elements beyond a reasonable doubt, then you may find the defendant guilty. So there's kind of echoes of jury nullification that's out there. But again, no one's going to allude to it. No one's going to talk about it. But right, that's how it would be utilized, because you see this sometimes pop up, in controversial issues. I think there was like someone who was drinking or selling unpasteurized milk in Wisconsin or something like that. As I recall, a jury found them not guilty. There was another issue, I want to say, with maybe it was shooting wolves or something like that. I don't know. That's probably wrong. But yes, prosecutors, judges, as well as defense attorneys are keenly aware of what laws a jury is going to be more likely to back up and support, which ones they won't. And that will definitely impact the situation. And it's not always what you may think, Tom, as well. It's not always what you may think. So I can expand on that if you want. Drop another question if you want to. VA Wolf, Tom, question. Do you think that Virginia's Governor Youngkin will veto this attempted assault weapons ban to come in Virginia? I've been contacting. We lost in part due to overall low voter turnout. I voted, but ... Don't know. I don't know enough specifics about Virginia politics other than I did hear about that senator who just won, or the newly minted senator who won, and her extracurricular activities online. But beyond that, I really don't know much about politics as to whether or not a governor is going to step in to veto. So I'm sorry. This one comes from Bob Smith. Does Florida's dumb open carry ban have any chance of being struck down in the court per Brune? So I'm going to expand that, Bob. That's a great question. So what this Supreme Court has basically said is that you need to have an ability to carry a weapon. And what they kind of left open, but I think it's pretty easy to read into this, is it could be open carry, it could be concealed carry. But there's got to be an ability to carry. We all have a right to carry out in public. So I think that with Florida having I believe now, permitless or constitutional carry law on the conceal side, I don't think it's going to get struck down from a Brune court decision. And I have not seen any challenge to open carry laws based on Brune. So I don't have any data points to relay either. But at least from my memory of reading the kind of the triumvirate of big cases, is obviously more, but Heller, McDonald, and Brune, as long as there's an ability to carry, which scared me in Wisconsin, because Wisconsin, we're the 49th state to get concealed carry. We just got concealed carry, give or take, a decade ago. We had constitutional open carry because it wasn't criminalized. So it was basically constitutional open carry. But I was really worried when I saw that, because theoretically, somebody who is anti gun can go ahead and basically, in a open carry state, could theoretically do away with concealed carry and say people can still open carry, right? And I'm not trying to create an open carry versus concealed carry war here. they're both valid to my mind. They both do different applications, and I think you should be able to do both. So I believe that. Let's change that from think to believe. Belief kind of speaks to more of what I hold. Think often kind of goes to what I think a court will do. This one comes from a Vera Geyser commenter. What are some steps you would suggest us to take to help remove some of the popularity found in our communities? I think you may be referring maybe to the bipolarity that I was talking about. Maybe not. If you're still here, just drop that down. What I referred to earlier on in the stream when I was talking about the bipolarity of what's out there. The polarity. So in other words, we're talking about just kind of, one side starts to go extreme, and then the other side develops more extreme elements in response to that side. And you kind of get this really deadly echo chamber. I think a lot of that comes from, candidly, the universities, from education, who's really doing a lot to push things in a very political direction. I think that we see a lot of that thanks to, in no small part due to social media, because people can create echo chambers. So they get to see their reinforcing views, both right and left. And I think as a result, there's kind of these, I don't know if the USCCA has published the video. So as some of you know, I do videos with the USCCA about one day a month. I make the trek up to West Bend, Wisconsin, about a half hour or so away from my house, and I shoot videos with them. So we're at the very end of our day. We just shot a bunch of videos, and then they'll trickle them out across a month or 2 months or whatever it is that they do. And Dylan, who's kind of the director, he said, "All right, Kevin," so Kevin Michalowski, myself, "Kevin, you and Tom think of a video to do." And Kevin looked at me and he's like, I got it. Dylan, I got it. And then he's like, "Turn on the cameras. I got it. I got an idea." Without telling me at all what it is. So we turn on the cameras and recording. He says something effective like, "Tom, what's wrong in the world today?" Something like that. Maybe it wasn't exactly his question, but it was something like that. And, whenever you see me say in any of their videos, like, I didn't know this was coming. I did not know this is coming. Like, you are seeing me hearing the question for the first time and processing it, not live because it's not live stream, but live insofar as, like, we're not reshooting or redoing things unless there's like a technical issue where there's no audio or something like that. And I got kind of this discussion in a very long video about markers for extremism. And I feel like this is creeping in on both sides of the political aisle. So I kind of came up with these, and some of these I covered and sampled from other sources. So I'm not claiming originality here necessarily, but some of these were confirmation bias. So maybe I had the idea, but I can't say that it wasn't subconsciously implanted from somewhere. So these are kind of some markers for extremism. I think you can see on both right and left emerging. One is the dehumanization of opponents. When you stop to see people from across the aisle as being humans, I think that's a dangerous territory. Another one is when you see prioritization of group identity above individual identity. If you think of, for instance, the Nazis in World War II, right? I mean, that's group identity above all else. It was a lot of things that they fell to. And I feel like we're seeing a lot of the group identity politics game coming up, which can be dangerous. I think mass disarmament of the civilian population can be extraordinarily dangerous and a marker for extremism. And I think ends justify the means logic. I think anytime you have people who are saying that the ends justify the means, those four things to my mind constitute a very toxic mix. How do we get away from that? I think that we need to have youth and individuals with a purpose and meaning that they can find. I think they need to have a better anchored identity as about who they come from, where they come from. And I think that if you have an identity, which of course is a very complex thing, but I think that when you have an identity and when you have a purpose, that you're far less likely and able to be manipulated by extremism forces, which is what creates that and drives that polarity. I think that's my shot at an answer at any rate. So, okay. Stephen R asks, any litigation on making states require to open carry? Yeah, I don't know if that was a response to what I just said before. Thank you, Stephen. No, not to my knowledge. If there is, I have not seen anything about that. And like I said, I would be worried about a potential backdoor attack on concealed carry. If I was super anti-gun, which I'm super not, but if I were, I would go back, I would reread the U.S. Supreme Court cases, and I would consider trying to make everybody to open carry. That's what I would consider trying to do. And you legalize open carry and you criminalize concealed carry. And arguably that creates a lane under the U.S. Supreme Court where it's like, hey, people can go out armed, people can go out carrying, they just can't do it concealed. So that's pretty scary. I hope we don't get there. This one comes from Larcools. Apologies on any mispronunciation there. Being from Arizona, we are pretty lax in gun control. Well, for now. We are seeing mass migration from other states and people trying to bring their laws here. What can we do to help curb this? Yeah, I mean, there's obviously been a lot of states that have been there before you. I mean, look at North Carolina, look at Virginia, look at Georgia, look at Colorado, look at New Mexico. I mean, you can just keep going on and on and on and on. I assume you're not asking me how do you curb mass migration, because I'm not sure I have a great answer to that. I mean, be less nice, pass crappy laws, just like the places where they came from, so they don't want to be there, I guess. I don't know. But how do you curb this? I think that to the degree that you still hold a majority, I would try to pass as many things as possible in the state constitution. You know, for instance, I made the comment about 20 or so minutes ago talking about how Colorado citizens probably really would have wished 20 years ago when the state was, or 30 years ago when the state was red, not purple. I'm sure that they would have wished that they passed state preemption, which would stop counties like Arapahoe County and others, that's Denver, from passing, magazine bans and AR-15 restrictions and all that kind of stuff. And I do see this time and time and time again. I was just talking to, just locally, someone was telling me about, there was a municipality that doesn't enforce some sort of really stupid law, and I don't remember what it is, but they've got some sort of really stupid municipal ordinance on the books. And someone brought up at a municipal board meeting of like, hey, why do we still have this out there? I mean, can't we just do away with it? And the village board or the city president or whatever the heck it was basically said, no one enforces it. Why bother doing anything with it? And someone told me that story and asked me what I thought about it. My response was, yeah, no one cares right now, but someday you're going to have a cop, a chief of police, a village board member, a trustee, whatever, who's going to make that their like mission in life to enforce that and get rid of it now. So I would, if I lived in a state that was subject to some demographic changes and potentially some voter pattern changes, I would try to lock in everything possible as soon as you can. And ultimately that's no protection or guarantee, but it's something. All right. A Screaming Comes Across the Sky asks, do you think permit to purchase schemes with excessive fees, wait times, and or that requires things like character reference will make their way to the Supreme Court? So we kind of already had that. That was the Bruin court decision, which basically said that you have to have shall issue and you have to have objective criteria for meeting shall issue. Now, of course, in response to Bruin, We've seen the U.S. we've seen New York State basically go into turn over your social media history, and other states have done all sorts of other things. And I see stories pop up in Reddit and social media and elsewhere talking about how, yeah, I had to wait 200 some odd days for my concealed carry. I do think that it's going to get to the Supreme Court. I don't think it's going to happen tomorrow. I think it's going to take some time to get there. But we'll have to see. I don't know. Time will tell. I do think it's an infringement, because a right delayed is a right denied, right? But we'll see where that winds up going. Okay. We have, let's see here. Darren writes, how do we put a stop to political parties using our tax dollars to make laws repugnant to Constitution, causing us to fight said laws or guidance? Yeah. How do we stop the government and anti-Second Amendment people from weaponizing the government against us? Generally speaking, right now, the way that the prevailing political winds are blowing, people who are anti-Second Amendment tend to be pro-use of government. So that's pretty difficult. I think the best way to do it, kind of going on what I mentioned about the Arizona question before, try to lock in as many referendums and as many constitutional protections into the state constitution as possible to make it as difficult to undo things, if not impossible, down the road. State preemption laws are a must, and getting as many things in there as possible. That's what I would do. This one comes from Mike Fang. How does Illinois force, quote, assault weapon owners to perform work and populate the state's database? I thought slavery went away with the Emancipation Proclamation. Thank you, Mike. I mean, they're going to try to force it through felony convictions and misdemeanor convictions. So through cops, guns, handcuffs, and jail. That's the easy answer as to how they're going to try to do it. We'll see where that gets them. So far, the registration numbers are quite low. This one comes from Pedro Roman. Shouldn't a violent felon have their 2A rights restored after complete their sentence and 10 or more years have passed without rearrest? At that point, should they not be labeled violent? Great question, Pedro. I suspect that we're going to have that addressed, at least in part, by the U.S. Supreme Court in 2024 from the U.S. versus Rahimi court decision. I don't know where it's going to wind up going specifically for felons, whether violent or otherwise. There's also a case I've covered on this channel going to the Third Circuit Court that folks have taken a look at there. Okay. This one comes from Tim. Is it a possibility to use the 2A to help keep a range open that a county would like to close because realtors have undue influence in the county board? Yeah, maybe money has undue influence with the county board, right? Obviously, a subdivision is going to pay a lot more taxes than a gun range, I bet. So there was a U.S. Supreme Court case involving Chicago. The year 2016 comes to mind, which dealt with Chicago trying to do away with and close gun ranges. And basically what the order was, look, if you don't have any ability to exercise your right, then, hey, that's all constituent part of the right. So I think it's going to be really vague. I think, candidly, Tim, unfortunately, you're going to wind up spending a lot of money unless you can get some sort of group like Firearms Policy Coalition, Gun Owners of America, Second Amendment Foundation, National Association for Gun Rights, or here in Wisconsin Institute for Law and Liberty. Unless you get one of those basically pro-liberty, pro bono organizations to get involved, I suspect there's going to be questions such as how many other opportunities to shoot is there within a driving range, and it's a largely undeveloped area of law. But I think that's definitely a big one. As suburban sprawls continue to expand, they're chewing up gun clubs. We have a perfect example of that not too far from where I live, where a gun club's been closed for the better part of 10 years now, and hard to say if they're ever going to get reopened. This one comes from Miguel Lopez. Why haven't the U.S. Federal Attorney Office not sued New York and other states that refuse to follow federal laws. Well, that's an easy one because the U.S. Attorney's Office is basically in control of whoever's in control of the executive branch, which is President Biden, who's not necessarily the most pro-Second Amendment individual out there. That would basically be Democrat on Democrat legal violence, and I just don't see that happening. We did see Democrats call out Democrats in New Mexico when the New Mexico governor issued those emergency health orders some months ago. So credit goes where credit is due, because we did absolutely see that out there. But there's a big difference between some tweets and some sideways glances as opposed to actual lawsuits. So I don't think that's going to happen, at least not right now. If my friend Blake is correct and the Democratic Party flips to becoming pro-Second Amendment in approximately 9 years, we'll see. We'll see. I remain extraordinarily unconvinced that that will happen, but I'm cheering for it to happen. This one comes from Jason. Any comments on the 56 pieces of gun legislation Massachusetts dropped a couple days ago? No, other than I'm not surprised, but no, I have not had a chance to review that. You know, one of the things, for better or worse, that distinguishes me and this channel from a handful of others is that this is not my full-time job. And the result is I can't do a video a day. I can't watch every single Second Amendment channel that's out there and social media and read every single case and every single piece of legislation or proposed legislation. I have a finite amount of time that I have to do my best to do the most damage. And by damage, I mean the best possible use of that time that I can make of it. I have not read gun legislation coming out of Massachusetts. And I'm not trying to belittle that as being inconsequential. Let me be clear, Jason. I have not had time in order to do that. I've had an extraordinarily booked up schedule. So I actually had 3 videos I was trying to shoot on Thursday that got derailed and pushed to Friday and got derailed. And now they're going to happen sometime this week. So Tom L, welcome Tom L again, asks follow-up question regarding jury nullification. What would be an effective way for the general public, the source of the jury pools, to be educated on this apart from jury instructions? Right. So from earlier, the discussion was jury nullification is a very real thing where a jury can basically, in essence, nullify a law by voting not guilty. But parties in court are never allowed to argue for it. And as a result, juries just kind of have to know about it. I think the easiest thing is obviously more discussion about it, whether that's in a classroom, whether that's in media, whether that's in Hollywood. I think that those are all important things. I think if there were to be a couple hit movies or TV shows that talk about that, that would be definitely a way to do it. There just haven't been, to my mind, any super high profile cases where we've seen jury nullification play a role in recent past. Juries tend to decide things. I have seen cases of jury nullification before. I had a gentleman once who was a juror reach out to me in a case that I didn't know existed, let alone anything to do with, who retained our office because he wanted me to reach out to the defense attorney in a case that he was the holdout juror in what was an 11-1 thing, telling his client he better take a plea because he thought that the law was crap. I want to say it was some sort of Second Amendment-ish law, and he didn't want to have any contact with the defense attorney, but he wanted the defense attorney to understand if you take this trial again, you're going to lose. But that's once. It's really not that common. Uncle Fester, great name. Do you see the Hearing Protection Act finally passed? No. I think if we got significant Republican majorities, even then, I don't know. I mean, so I talked to lots of people in politics on both the right and the left side of the aisle, and there's a lot of people, and I did an interview with a United States Congressman, Andrew Clyde, on the channel a couple weeks ago, and I kind of got at this pretty early on with him of, look, right now Republicans are the pro, by and large, the pro Second Amendment party. And they are just lions on the campaign path when we're talking about Second Amendment. But they are kittens when it comes to being in DC or wherever your state capital is, when it comes to actually passing laws that protect our rights when we're talking about Second Amendment. And he tackled that, and I thought he did a really good job of that. I've asked other politicians, not on camera, not on the channel before, and what some of them candidly tell me is, look, there's a lot of Republicans out there who they say they're pro-gun. They're not really pro-gun. They're not anti-gun. It's just they don't really care about it. And if they have the opportunity to compromise on that to look to what they believe will look good to their constituents, they'll do it. So there's a portion of those folks in the Republican Party, and we've largely seen the annihilation of the so-called blue dog Democrats from the 90s and before, who are kind of culturally conservative Democrats, people who might be considered pro-gun. There's still a few of them out there, but that's it. I think that the Republicans would have to get a pretty sizable majority, because I don't think that there's enough Second Amendment warriors in the Republican Party to push the needle that far. So I think that that's kind of it. Primal Rage asks, is there any new word on pistol braces? No new word on pistol braces. I covered that maybe about 40 or so minutes ago. Quick recap. We're the very first channel to break the temporary pause placed on the pistol brace issue. I think it's ultimately going to have to be decided by the Supreme Court. That's just where I see that going, because the Fifth Circuit, I don't think, is going to reverse it. So your pistol braces are likely safe for a number of weeks, if not months, and possibly much longer, hopefully forever. Stephen again asks, what organizations are best to join to benefit from any injunctions if limited to membership? Looking forward to December 12th with possible U.S. Supreme Court action. The best organizations out there are, in no particular order: Gun Owners of America, Firearms Policy Coalition, Second Amendment Foundation, National Association for Gun Rights. Those are 4 organizations that are consistently bringing the fight in the trenches. I would donate to them before almost any politician. There are some politicians that are absolutely warriors for the Second Amendment, Andrew Clyde being one of them, Tom Massey being another, to name a couple easy ones. But those are the people who are tangibly able to move the needle with lawsuits. So I would absolutely be paying attention to those organizations. And when it comes to injunctions coming up on December 12th, offhand, I don't know what specifically you're referencing. I may have some note tucked away in my show notes referencing a December 12th deadline for something, but as I sit here right now, I can't name anything. This one's a super chat. It's coming from Salty Rebel. Thank you, Salty. Do you foresee a day when we'll have national reciprocity with those of us in constitutional carry states? Thank you, and I'm voting for you in the Gundy. So I appreciate that, Salty. Don't forget, when it comes to Gundy voting, you're allowed to vote every single day. Shameless self-plug there, I guess. So you have an interesting question, because I'm assuming what you're asking is this. You live in a state with constitutional carry. In other words, you do not need to have a license to conceal carry. You don't have a license to conceal carry. So what do you do if you travel to a state that requires licenses, right? Right. I think for the foreseeable future, you're just going to be stuck. I hate to say it. I think I don't see the licensing regime going away anytime soon. I'm not saying that because I support it. I'm saying that just to be honest, as far as what do I think? I think it's not going away anytime soon. And consequently, even if Wisconsin, my home state here, were to turn into a constitutional carry state and do away with our concealed carry laws, I would not do away with my concealed carry license. So, right. Thank you, Salty. Grady Goodwin asks, how do you see national reciprocity succeeding? I'm somebody who's I have mixed views, to be honest, on national reciprocity, and here's why. Um, I live in a state that is pretty darn purple. Generally leans a little bit more blue, but reasonably purple. For the time being, we have a pretty strong Republican pro-Second Amendment firewall in our state legislature. That might change in the imminent future, but that's a separate discussion. Consequently, the threats to my Second Amendment are coming from DC, not from my state capital, Madison. So the more rights we start to run through DC, the more worrisome that becomes. It's like a Pavlovian response to training a dog, right? If we teach DC, hey, you guys can mess with states' concealed carry. Don't you want to get involved in that? Because, hey, now it turns into an interstate thing. So does that mean that DC can regulate how you carry in your states? Or are they only basically saying every state must recognize each other's license? Are they allowed to put licensing restrictions in place? So if it comes out right, obviously full-voiced, full-throated support. But I see this as a little bit of, I'm not going to go so far as to say a Trojan horse issue, but an issue that's at least more nuanced than I think a lot of people give it credit for when it comes to running reciprocity through DC. I have some reservations about that. As for how do I see it going, I think it's going to take a Republican majority, a Republican, a pro-Second Amendment majority, whether it's Republican or Democrat or some combination of the two. It's going to take that. This one comes from Don Ireland. Businesses are allowed to restrict speech of their employees, but government is not, because 1A is a restriction on government. So why is government allowed to restrict concealed carry on government property? So great question, Don Ireland. The issue when it comes to when government restricts concealed carry access on something, they are doing so by basically using what I would term sensitive location laws. So they are deeming something to be a sensitive location. Per the June 22nd of 2022 U.S. Supreme Court case of New York Rifle State Pistol Association v. Brune, there's only a few canonical categories. There's only a few like masterclass categories that the government's allowed to hold out as being sensitive locations. They're allowed to hold out courtrooms, polling locations, legislative bodies when legislative chambers when legislative bodies are in session, and schools. Those are kind of the dimensions that they've outlined as being, yep, you can sensitive location these, and then places that are near enough to those you can do. Does that mean post office is a sensitive location? Brune said that places where the government is exercising like authority in its heartland domain, they had some sort of obscure wording like that. The point being is I don't think government restrictions on like wildlife parks, like Yellowstone, stuff like that, I don't think that's going to stand when it comes to ranger stations, right? I don't think, I think airports are going to wound up to be upheld beyond security checkpoints. Like as a practical matter, I don't see that changing. You get to a lot of places where kids congregate, like playgrounds and like parks in suburbia with jungle gyms, that kind of stuff. There's a court that struck down a lot of sensitive locations, but they upheld that as being similar enough to schools. They decided it was within the same sphere. Right? You get to like hospitals and banks and just all these different places. I think those are going to get struck down. I think those are going to be coming out in the wash someday, assuming things don't really move. I think that's going to kind of stay where that is, in the sense that it's not sensitive location, but time will tell. All right, I'm just going to have time for a couple more of these guys. This has been fun, And we'll see how this video does once it's all done and being uploaded, and we'll see if people like it. And obviously let me know as well whether or not you guys got something out of this. The best way of doing that, you see me do this in the videos, but we have shelved projects on the channel because a couple of videos in the project just didn't do well. So I just shelved them. The way that videos do well is basically viewership, which is if you see a video, if people click on it and they click like and they leave a comment, the YouTube algorithm says, oh, this must be a good video because someone clicked on it when they saw it, in like your YouTube home list of videos. They watched it for a while, they clicked like, and they left a comment. So that's how YouTube basically grades whether or not something's a good video or not. So we have shelved a lot of projects because videos didn't do well. Like, for instance, the racist history of gun control, where we're looking at just the ugly past of gun control. I think I had a 6-part video series worked out on that. Right, that just got shelved. Did not wind up going into that because the first 2 videos both did awful. I might revisit that at some point. But at any rate, if you wonder why YouTubers, doesn't matter if it's me or someone else, why we ask for those likes and so forth, because that helps to drive the algorithm, which helps to do our videos and all that kind of stuff. Oh, here's a fun one. This one comes from David Rikers. Why do you endorse an insurance company like USCCA when there are so many limitations / restrictions on their protections / coverage that are not immediately obvious? Great question, David. So I've actually shot a video. So I've joined a handful of organizations, Law Shield and some others, because I get this question kind of pumped at me a fair amount in the comment section of videos. There's been some controversy regarding some folks trying to whip up some stuff, sometimes specifically at the USCCA, sometimes more generally at any place that's not a group called Attorneys on Retainer. A lot of the controversy out there is simply wrong. There was a gentleman on another channel who I won't name, but he did a video where he made it sound like if some woke prosecutor decides that you're guilty and you get charged, that insurance companies won't cover you. Like, that's just flat out wrong. That's not the way this works at all. It's not ever the way that it's worked. Doesn't matter if you're talking USCCA, Law Shield, CCW, SAFE. It doesn't matter if you're talking about Attorneys on Retainer, on AOR. They will all do their own independent analysis as to whether or not they believe the case involves a genuine issue of self-defense. And I've called Attorneys on Retainer. I've called Law Shield. I have talked to Law Shield attorneys. I've talked to CCW SAFE. I've talked to all of these guys. They all say the same thing. They're all going to run their own independent analysis about whether or not someone is going to be covered. And they're going to do that primarily looking at whether or not there's an actual issue of self-defense. David, you specifically asked about USCCA. Our firm represents any number of USCCA folks who have been charged in a crime or involved in a deadly force incident, both now as well as over the years. There have been cases where right at the headwaters, right when something has happened, and USCCA hasn't decided, like any of these groups, hey, if we're going to cover this person yet, because all we did is we got a phone call and like we don't have any information yet. My attorney talks to them, and I've had on a couple occasions, my attorney comes back to me and I say, if I'm busy, I don't have a chance to talk to these individuals. And I ask them, hey, how did this sound? Does it sound like could be a good case? Is it clear-cut self-defense or what? There was one recent case where the attorney said, it wasn't very self-defense-y. They're probably not going to cover. And then the USCCA absolutely covered them and overnetted us a check. So I think that there's massive holes, David, in specifically the Attorneys on Retainer policy. 90% of the time, give take, if you're involved in a firearm self-defense incident, you're not going to have to pull the trigger. That's what the studies say. That's what my own personal experience dealing with a lot of people who have been involved in self-defense issues. Any point in time, my firm is between about 4 to 15 defensive gun use clients. And I can't even tell you how many more call us. I don't know. The vast majority of the time, people are not pulling the trigger. The mere display of a firearm is more than enough to get people to run away. That means that the vast majority of the time, you're probably not going to be facing felony charges. Most of our self-defense gun cases, the vast majority of our self-defense gun cases are misdemeanor cases. Misdemeanor. In other words, they're crimes, but they don't rise to the level of being a felony. Why is that important? Because attorneys on retainer will not cover you on misdemeanor cases. So if you want to talk about exclusions, and look, I realize USCCA has got some exclusions. Law Shield's got exclusions. CCW Safe's got exclusions. They all have exclusions. None of those exclusions, first off, I've ever seen one of them actually come up like outside of an academic discussion on the internet. Number two, though, is the fact that the vast majority of self-defense gun cases are charged as misdemeanors, which means attorneys on retainer won't represent you. Do you ever see them talk about that exclusion? Because that feels like an exclusion to me. And let me be clear, I am in support of all these organizations, including attorneys on retainer, insofar as we're all on the side of you. We're all on the side of the folks. We're all on the same team. So I think that it's a brand new product that AOR has invented. I hope to see it improve. I kind of look at this as version 1.0. I am cheering for them to improve it. I put a call into their office actually just under a week ago, trying to reach Mark Victor to talk to him about all the exclusions and questions that I had to make sure I was understanding it right. The staff member told me that they were going to get me, they're going to get my message to him and identified who I was. They said that I should hear back, if at all, in the next day or two. It was 6 days ago now. I'm 0% being critical of Mark. I have no idea what his schedule was. Maybe he had a big jury trial. I don't know. I'm not being critical in that sense. But to your question, David, why am I in support of USCCA? Because the USCCA is the only company that will give you literally a blank check to hire the best attorney you can find. Period. You see the best attorney in your town, or your state, or your jurisdiction, that can be your USCCA attorney. Law Shield will lock you in. CCW Safe, I can't recall off the top of my head if they will hire an attorney for you. CCW Safe has a weird thing where they say that they are going to manage. You're agreeing to waive confidentiality with your attorney and them, so they can talk directly to your attorney and that they can manage your litigation. I've never talked to a CCW Safe attorney, so I don't know how scary or real or not real that phrase is. USCCA's got that recoupment policy in there. The truth is that it's in all the insurance ones. The difference is USCCA is honest and upfront about it, but the law compels insurance companies to, if the government wants to force it, they can. But the USCCA has never once exercised a recoupment policy on anyone, and they have every possible financial and incentive otherwise to never do it. Why? So they get back 30 grand, 50 grand, 100 grand, however expensive the representation was, 200 grand, 500 grand, whatever. If they start exercising that, do you realize how many members they're going to lose? Like, it's not worth it. They'll lose more than whatever they were able to claw back. So at the end of the day, money talks. I pay attention to which way, which side of the bread someone's getting buttered on. But yeah, that's why I'm in favor of USCCA. But I'm not saying that these groups are evil or bad or something like that. I just think that these are not all the same product. And I actually have a video, like I said, that I shot that's like long. It's like 25 minutes. It should be going up this week. I don't know, man. It could wind up getting pushed back, but where I go all into that. Machiavelli sucks. Super chat. Thank you. Machiavelli wrote, what lawyers won't represent you? What lawyers won't do what? Now, I'm not sure what that's in reference to specifically at this point. Is that in relation to when I said that attorneys on retainer, their policy doesn't cover misdemeanors? Is that possibly what you're referring to? Yep. Okay. You said yes. So yeah, if you go to their website, they give 3 dimensions of when, and I don't have their website up in front of me, so I'm doing this from memory. It could be wrong, but one of them is that you're charged or are likely to be charged with a felony. I think that's literally number 1. So again, the vast majority, at least in Wisconsin, the vast majority of self-defense cases get run as misdemeanors, which means that I think you're eligible to hire them at like a reduced rate, but you're not going to get the included representation that's as part of coverage, so to speak, where you're not stroking an additional check. Again, subject to change. And I did call them to ask that question, and I've not heard back. Also, another reason, circling back to your question, David, is why I like the USCCA. USCCA has a very good bail coverage policy. All these groups are always changing them. I don't have like a particular anchor point. Another problem with attorneys on retainer, and not specifically with them, but just the concept of a law firm doing this, because it's not like I haven't been approached about doing something like AOR over the years. There are laws in many states, Wisconsin's one of them, where it's illegal for a lawyer or law firm to post bail on behalf of someone else. So, David, did they tell you that they're not going to post bail for you if you're in one of those states? Because it's more than a couple states. Now, maybe they've got some sort of nifty workaround. I don't know. But again, this is why I called them, because I wanted to have a conversation. I heard Mark's a good guy. More than happy to have that conversation with him. But, all open questions, one and all. So bottom line, why do I promote USCCA? I know them well. My law firm has worked with them as well as other places as well. We have a fantastic track record with them. They're a fantastic organization. Stem to stern, A to Z, soup to nuts. The crap you see people run online is mired with issue oftentimes, most of the time, maybe all the time, hard to say. So hopefully that kind of addresses that. I'm happy to go into that more, but I'm going to skim, since Machiavelli gave a super chat, make sure I didn't miss anything else you said, Machiavelli. I do not see other questions from Machiavelli. Although I do see, when skimming, Jeff wrote, seems like these type of insurance lawyers may represent you during the criminal part, but not following civil litigation. Yeah, it's possible. As a criminal defense attorney, I can't really address that. And frankly, I realize that civil litigation is something that people worry about. You hear about Kyle Rittenhouse got sued civilly. Guys, I have never seen anyone, aside from these high profile cases, ever get sued civilly. I don't know what the statistics are, but if someone told me that less than 1% of people who use their firearm defensively was sued civilly, I would say that sounds right. I would say that sounds right. So I think that the things that move the needle for people when it comes to these defensive force coverage options are they're all gonna run their own independent analysis as to whether or not you will be represented. So that's that. They're not going to depend on what some woke DA or prosecutor or anything like that says. They're all going to run their own independent analysis on it. That's number one. And I say that as an ex-state prosecutor, criminal defense attorney who knows how these organizations, I've talked to these organizations. So like the guy who wrote that video, don't know him. Maybe he's a super great guy and people just gave him a lot of bad information, but that was insanely untrue and unfair for that, what it's worth. And like I said, I don't know where he got that bad information from. But then the question is, who's going to be your attorney? You don't have any choice in who's your attorney with Law Shield. It's whoever it is that they contract with. CCW Safe, I think they can hire someone for you. And I think you may have, like, you can suggest people or not. But at the end of the day, it says right in their policy, they're going to choose someone for you. So you don't have any say in that fundamentally. Attorneys on retainer, well, it's those guys from Arizona and Hawaii. Those are the guys who are going to be representing you. And I've also seen people mention online the fact that they're actually anti-gun attorneys on retainer. Mark Victor ran for like U.S. Senate or something like that under a third party back in the 2019 under the Live and Let Live party. And you can find his website, and he's got a section in there talking about Second Amendment, and he's pro red flags, and he's pro. Someone showed it to me. He's pro letting basically cities and local organizations pass gun control if that's what they want. He's actually in favor of homeowners associations passing gun control if that's what they want. You know, I tell people, don't look. Most defense attorneys are very left wing, and I'm not saying Mark's left wing. I have no idea. I'm inferring he's pretty libertarian based on that party name. Possible anarcho-capitalist, I don't know. But taking him out of the conversation, most defense attorneys, most very skilled defense attorneys are going to be left-wing. Odds are the best defense attorney near you is going to be probably on a personal level very anti-gun. So if you think that attorneys on retainer, that those particular attorneys they have there are a fantastic option and you like them, and if you're fine with the misdemeanor exclusions right now, as well as the possible issues with are they going to be able to post bail for you or not, then go with that. I will tell you that I know of 4 Law Shield attorneys nationally. I like all of them. I'm sure there's duds out there, but Law Shield's 4 for 4 as far as I'm aware. As far as who are their contract attorneys. CCW Safe, you have no choice. And USCCA, you can hire whoever you want. How do you beat that? So, at any rate, Mandarin question, but it's been on my mind. Are there any other, just while we're on that, so we can finish beating up the legal insurance and all that kind of stuff? I'm just skimming right now. One of the best uses. Why don't I teach the Second Amendment as it is? I mean, I literally do that, but okay. Okay. I don't see any other USCCA things. So, all right. Maybe we're going to grab only one more because we're coming up on the 2-hour mark. I've got a hockey game in not too long that I've got to play in. So I start to get ready for that, eat an early dinner. So I don't know if I'm getting old. So I don't have any reflux issues on the ice. Okay. Art Pollard asks, what state constitutional amendments can we add to protect our Second Amendment rights if the state already has a constitutional right to bear arms? There's always more to be done. Yes, there is. I would say, how specific is your constitutional right to bear arms? Is it just you have a constitutional right to bear arms, or do you have a constitutional right to conceal carry? Do you have specific places that have been designated as sensitive locations? Do you have state preemption? If you really want to go hardcore on this, do you have a constitutional right to own semi-automatic handguns with 50-round magazines and to carry them, right? Do you have a constitutional right to have gun stores and FFLs? I mean, was it Missouri is the one who passed the Second Amendment? I'm going to get this wrong, like the Second Amendment Preservation Act, which, you know, the feds have really come down on. You know, you can do stuff like that. Basically, a lot of the playbook that we have seen when it comes to sanctuary cities dealing with immigration issues, a lot of that, not all of it, but a lot of it does map to being pro Second Amendment elsewhere as well. So, right. All right, guys. 2 hours. 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 2 I think, yeah, have a great game, old man. Yeah, thank you. It's I don't know how many more years of hockey I have left to me at this point. It's a non-checking league, but there's no such thing as non-contact hockey. So I think the next time I get a major injury, they'll probably hang up the skates. Speaking of, if you've made it this far, please be sure to thank the wife, Jen, who has been graciously copy pasting your questions from the chat onto a Google Doc, which I'm actually reading off the Google Doc, which he's copy pasting, and occasionally I'm going back to the chat. So please be sure to thank the gracious wife for not only letting me get away from things and all that kind of good stuff, but also non-checking equals hacks abound. Yeah, true. There's a lot of cones out there. Less these days though, but right. Guys, I enjoyed this. If you want to see more of this after the video is done going live or done being published, post it up or post up comments in that official video, because that's what's actually going to help to drive the algorithm on that. Of course, don't forget to hit the like button if you haven't already. Watch the community section. Let me know after this video is up. Let me know how many of you guys actually engage with the community tab, because when I've done live streams before, not for the channel, but for members, people said, I never saw this published anywhere, and I've been publishing things in the community tab. So did the channel update work for you? Does it not work? Let me know. Guys, from both Jen and I here in Wisconsin, we appreciate it. If I was more on the ball, I'd have a quote of the day for you. Maybe I actually have one just laying around on my desktop somewhere, because that's where I tend to put them. All right, here's a Kipling quote, just laying on my desktop. Our quote of the day comes from Kipling, quote, "The sea, relentless and unpredictable, is loyal only to the strong. In the midst of rough waters, the weak find only sorrow." There you go. Be sure to check out our quote of the day, also on Twitter, as well as in our community tab. Thank you very much, everyone. I'll see you in the next one.